Good afternoon, everybody. Welcome to Table Talk for Education, hosted by EdPower. My name is Michelle Kinley. I am the Chief Operating Officer here at EdPower. And today we have an amazing guest with us here at the table, Tonya Gentry. Tonya has a career in civil rights and equal employment opportunity enforcement spanning almost 2 decades. She's assisted educational institutions, organizations, and professional groups coordinating successful compliance efforts to create both educational and workplace environments free from unlawful discrimination and retaliation. After receiving her Juris Doctorate from the University of North Carolina School of Law, Tonya has held roles including Equity Director, Attorney, and Advisor for the Windsor Group, and Senior Attorney for the U.S. Department of Education's Office for Civil Rights. I can't even wait to hear about how that worked out. Tonya, welcome to the table.
Thank you, Michelle. I'm so happy to be here. Thank you for extending the invitation.
Absolutely. I know that we're going to have a great conversation today. I was super curious the first time I met you just about what it was like to become an attorney, what made you want to do that, and then specifically civil rights. We both live that world and have for several years now, and think it's just really great for us to put out there for women, and especially women of color, what it's like to be in your role, how you got there. You had some bumps along the way as far as your decision making to go there, and so I'm really curious to learn about that and let our audience hear that as well. So can you start by telling us what led you to become a civil rights attorney?
Sure. So I did not take a traditional path. As you noted, I went to the University of North Carolina School of Law. I started out at Virginia Union University. That's where I received my undergraduate degree in biology, and I minored in chemistry. So I had the idea that I was going to be a doctor. However, even when I was a young child in grade school, I would change my career path like every other day. So I don't think that my parents were too surprised by the fact that I did a total 180 once I was in college. So what really inspired me to go to law school was the summer before my senior year at Virginia Union, which is located in Richmond, Virginia, by the way. I took an internship at the National Institutes of Health in Rockville, Maryland, and it was a health policy internship. Prior to that, every summer I would be in my white lab coat, working in various labs. I had a part-time job at the Medical College of Virginia, and so, like I said, initially I was dead set on becoming a physician. However, I really enjoyed dressing up and wearing like adult clothes. I got to wear like suits and dresses, and so I thought that was super cool at 2021, and really had the opportunity to talk to a number of individuals that were using their science background in different ways that I had envisioned. I was the first person to go to law school in my family, so we didn't have any lawyers, but we didn't have any doctors either. So I was pretty open to the possibilities of what I could do with my degree. So after completing that internship, I had a conversation with my parents, and they're like, "Hey, you do like to talk a lot, so why not apply to law school, see where it goes?" And I literally applied to I think it was 6 law schools. I really wanted to go to the University of North Carolina. I'm originally from North Carolina, and so even though I went to college in Richmond because I was offered a full scholarship, a full academic scholarship, at the time, UNC was the state Harvard of North Carolina. And so I said, well, you know what? If I get into the law school of my choice, then it's meant to be. And if not, then it's not meant to be. And clearly it was meant to be, because here I am. So.
So experiences there?
Yeah, so
I want to ask you, were you the type of child that always had the right answer?
No, I was the type of child who always wanted to have a discussion about the answer and why it was right. let's dig deeper. Let's talk about why you believe this answer is right. I was the why kid. I remember I tease my mom about this all the time, even now. Many years later, I always tease her about the fact that she would get really frustrated with me because I was that why kid. So every time she answered one question, I would follow with why. So yeah, I've been the why kid since I could talk. So once I got to Carolina, like I said, I majored in biology. I had a degree in biology and chemistry. And so, of course, I was thinking about maybe the health law route or studying for the patent bar. I ordered the patent bar materials because you don't have to actually have your degree in order to sit for the patent bar. I don't know if a lot of people know that. But once I got the materials, it was like watching paint dry. It was so boring. I thought I was going cross-eyed. Like it was horrible, like staring at that material. So I ended up selling those books pretty quickly. It was like literally like my first semester in. And then I started just brainstorming different paths that I could take. And at that time, both my roommate and I met Julius Chambers. He's now deceased, but he was a civil rights great. Right. And he took me in as his mentee, and I joined the civil rights moot court team. After working with him, also became involved with the Know Your Rights campaign. So we would go into different areas in the community. So the University of North Carolina is in Chapel Hill, and right next door to Chapel Hill is Durham. And so Durham at the time was a bit more of an urban area, more metropolitan area. And so we would go into some of those communities and just inform individuals of, what their rights were, should they be stopped by the police. Started studying a lot of the issues involving like the pipeline to prison epidemic that's still unfortunately ongoing now 20 years later. And the rest was history. I knew that I wanted to have a career in civil rights. I wasn't quite sure what that might look like, but I knew that was the area of law that I wanted to explore.
So you and I have been under the tutelage of greatness, I see. And we both, you with your attorney civil rights situation, and then both of us with Dr. Donna Elam, who is a civil rights great. We got to give a shout out to her, because I don't think either of us would be where we are if it weren't for the groundwork that she's laid for us over the years. So shout out Dr. Elam.
Absolutely. I agree 100%.
So tell us about some of the cases that you've worked on.
Yeah, so I'll back up a little bit. And I'm aging myself, but I have to be transparent. 9/11 happened while I was in school. And I don't know if you remember, but everything went awry. Like the economy sank. I mean, people that were 3Ls at the time, they were in their third year of law school, that had job offers, they fell through because everything just tanked at the time. And so I was one of those individuals who had a job offer. I had signed up to take the bar exam. I was going into my 3L year, and it was a federally funded grant position. And so, funded through a federal grant. And due to the lack of funding, the position was no longer available. It was available, but the funding wasn't available. Yeah. And so they were really sweet and said, hey, if you come here and work for free, and we can reapply for the grant. And I have bar loans. Like, I can't do that. What am I gonna do? So again, as I noted earlier, I was the first person in my family to go to law school. So I had no clue. And I started reaching out to individuals. And one of my good friends from college said, have you ever thought about working for the federal government? Because if you work for the federal government, it doesn't matter what state you're licensed in, as long as you pass the bar exam in any one of the states, you can practice. That sounds pretty cool, because I'd already taken out a bar loan to pay for my bar. I couldn't afford to like even pay for a different state. And I don't even know if I had like the bandwidth, the mental bandwidth at that time to take another bar exam. So I took his advice. I started applying for federal positions. At that time, I got a lot of feedback from various individuals saying, you know, it's really hard to get on with the federal government, especially for your first job out of law school. But as fate would have it, I got a call from the regional director for the Office for Civil Rights at the Dallas office. And it was 2 days before my bar review class began in order for me to start studying for the Georgia bar, because the offer that I had was in Georgia originally. We had a conversation, and by the end of the conversation, he offered me the job. The catch was, though, they had brought in 2 attorneys, well, 2 new graduates prior to me joining the office. And they were unable to pass the bar exam. So at that time, the government said, hey, we are not going to lose any more money. We'll bring you in, but you have to come in as an investigator. We'll wait for you to pass the bar exam, and then we'll convert you to an attorney. So the first 9 months of my career with the federal government, I worked as a civil rights investigator. And then once I got my bar results, about 3 or 4 months in, took some time for me to fly back to Georgia, get sworn in. By the time we got converted, it was about a year. So, and the rest was history. I was an attorney with the Office for Civil Rights from there.
Do you live in DC?
No, so when I applied for the jobs, I listed DC. No, I listed Atlanta as my first choice because Office for Civil Rights, there are 12 regional offices. There's one in Atlanta, there's one in DC, so that was my second choice. And then Dallas was my third choice. Atlanta didn't call me back, DC didn't call me back, Dallas did. And as I indicated, it was literally 2 days before I was scheduled to start studying for the bar. So of course my studying, it was a lot smoother knowing that I actually had a job offer. So I told Dallas yes. So I ended up going to the Dallas office. I didn't know anyone. I didn't have family. I packed up everything and moved, and I ended up staying with that office for about 14 years. So Dallas is like a second home to me now. I have a lot of friends and colleagues there, former colleagues. But you asked me about the types of cases that I worked on. So the Office for Civil Rights, it falls under the U.S. Department of Education. So essentially I was working with K through 12 schools as well as colleges and universities. And at that time, that particular office had jurisdiction over Texas, Louisiana, Mississippi, and Arkansas. So those were the locations that I was traveling to. And the types of cases that I worked on included racial discrimination cases, discrimination on the basis of sex, disability, and age, all within the educational context.
Can I pause you for a minute and ask you to just explain to everyone, in general, what is the Office of Civil Rights?
Yes, so the Office for Civil Rights is the enforcement arm for the United States Department of Education, which essentially means any K through 12 school, college, university, vocational ed institution that is receiving federal monies from the U.S. Department of Education, which is essentially like all schools, even private institutions, they have to comply with the laws that the Office for Civil Rights has jurisdiction over. And so the laws that the Office for Civil Rights has jurisdiction over includes cases that deal with racial discrimination, discrimination on the basis of sex or gender, disability, and age, as I mentioned before. So that's the gist of it. their jurisdictional authority, and like I said, the types of cases that I worked on. So within those particular areas, there are different types of discrimination or different types of cases that fall under each area. So when I say like race discrimination, sex discrimination, that can include something called different treatment. And that's like intentionally treating someone in an adverse way or in a negative way based on their race or based on their sex or gender or based on their national origin or based on disability. Another form of discrimination would include harassment. And there's certain criteria that a case has to meet in order to fall under a harassment claim, but it's like, you know, is it a severe, persistent, pervasive, hostile environment that is so bad that it's preventing the student from participating fully in the educational environment? And again, that's at the K-12 level as well as the post-secondary level. Another form of cases that I worked on included retaliation cases. So if a student goes to the school and says, hey, I'm being harassed based on my disability, or I'm being treated intentionally different based on my race, and then the school takes adverse action against that person, then that's a retaliatory claim. So I worked on those types of cases as well. And I also worked on a lot of the Title IX sexual assault cases. You know, I'm sure everybody's familiar with the Me Too movement that occurred several years ago, and it's still ongoing, but 5 or 6 years ago, it was really at the top of everyone's interest. So worked on a lot of sexual harassment, sexual assault complaints, as well as Title IX athletics. A lot of people don't think about Title IX athletics and civil rights, but it absolutely falls under that umbrella. And so I counted a lot of equipment going into locker rooms, you know, worked on, I was at Baylor University, LSU, and you know, counting uniforms and making sure that the facilities and the equipment were equitable among both male student athletes as well as female. So transgender issues, yeah. So yeah, I was there for 14 years. So Michelle, I did a lot of different cases.
Yeah,
A lot of work.
that's so interesting. Oh my gosh, I don't even know where to start. So the Me Too movement, was that basically surrounding higher ed? I mean, I know it surrounds everything, but the cases that you worked on, were the majority of them within the higher ed space?
Yeah, I wouldn't say the majority, but I would say the ones that were most popular or most well known. I don't know if you recall, I know ESPN had featured some of the cases, and the one that involved Baylor University's football team. I was the lead attorney on that particular case, so because that had national attention, it was well known. However, I received a lot of cases at the elementary and secondary level, unfortunately, as well. And I will say that I had to receive training as far as like utilizing trauma-informed techniques when talking to young children. I had cases involving, you know, kids on a school bus that were kindergarten, first grade, where these types of allegations came to be. So again, I would say it was probably equal as far as like the types of cases that I had, like between elementary and secondary schools, as well as at post-secondary level. However, the post-secondary level, as I noted previously, it was much more popular. They were receiving a lot more attention at the time via the media and other.
Yes, for sure. So before we move on, I want to ask about sort of like the day in the life. So if you received a case, and I want to be you, what does that look like? Is that, you know, were you scared at all? Did you have any type of pushback? Is it you received the case and then you have to go visit? Like, sort of, what does that look like from your standpoint?
Yeah, so and I do want to clarify again, even when I started with the Office for Civil Rights, I wasn't really sure about what to expect. However, the type of cases that I worked on were more from an administrative approach. So I never stepped foot in a courtroom. I tell people all the time, if I had to go to court tomorrow, it would probably be malpractice because I don't know anything about the decorum or anything, right? So the approach that I utilized when I had cases was, like I said, from an administrative investigative standpoint. So I would get the case, I would typically call the complainant, clarify the allegations, make sure that the office had jurisdictional authority to even pursue it. And then after that, I would engage in case planning. And that's just identifying the types of resources that were needed, any relevant case law, any prior cases that I might have worked on or my colleagues may have worked on that might help me or provide guidance, and also try to ascertain exactly what the complainant was seeking. During my tenure at OCR, there was a shift towards encouraging mediation efforts to preserve resources as well as get relief to the complainants and the recipient institutions as soon as possible, effective relief, that is. So I would evaluate it and see, is this proper for mediation? Because I am a trained mediator. So essentially just case planning, identifying like what resources I would use, what resources I already had, or if I needed additional information or help, et cetera, then I would identify that and just go from there.
Thank you, because I think that, you know, when people are looking into this type of thing, you don't think of being an attorney outside of court. You know, like when you're not really in the trenches, you don't really realize that you don't necessarily have to be in front of a judge every week. So I appreciate that description. If you're comfortable, would you be willing to share both maybe something that was super exhilarating during your time there, as well as something that maybe brought you to tears?
I had many moments. I tend to be a crybaby, so but I got better as time progressed. One case in particular that stood out to me was I went to a very small town in Texas. Like there were 3 schools in the entire district, literally like 1 elementary school, 1 junior high school, and 1 high school. It was so bad, Michelle, that the last like 5 to 7 miles weren't even on the GPS at the time. Like literally it just went from like a line to a black blob. And so it was me and another one of my colleagues who was a non-attorney investigator at the time. He was one of my mentors. He had been there, I don't know, 20, 30 years when I got there. So he took me under his wing. And we were just like hoping that we got to the right location. We drove on this like rocky road. It wasn't even paved. Long story short, I wasn't able to substantiate her claims. However, I just remember her grabbing me and hugging me and saying, excuse me, I'm so happy that you came. Like the fact that you came down here and listened to me, it means everything to me. And that was very touching. And she literally started crying and I was trying not to cry, but I don't think I was successful. But just knowing that, and at the time too, she had indicated that I was the first Black woman attorney that she had ever seen wearing a suit and a federal badge. And that meant everything to her and meant everything to her young children to see me in that role. So that was really touching. As you can see, I'm getting choked up now. Take a drink. So yeah, that probably stood out the most, but I had a lot of victories in that role, which is what led me to eventually leave the Office for Civil Rights and begin consulting on my own. I was doing essentially the same work, but that feeling is something that can't be replaced. When you have that level of appreciation coupled with knowing that you're fighting the good fight and you're doing great work, and you're giving it your all, it made for some very, very special moments throughout my 20-year career.
Well, thank you for all that you've laid all of us. Ooh, okay, so.
And I will say too, like I think
Let's
just
see,
to,
where do we go from here? So we both, go ahead.
Oh, I'm sorry. I don't know if there's a delay, but I did want to just address what you said as far as a lot of individuals not realizing that there are civil rights attorneys that don't go to court. I think that's important. I've even had this conversation with family and friends. A lot of times when they're, with the police brutality cases that have been like highly publicized, there are a lot of civil judgments. And so there are different ways of ensuring that the civil rights laws are enforced. But again, the work that I did was more from the administrative level, because the government says, hey, we have this agency that's put in place to ensure that the laws are being enforced. The cases that go to civil litigation that you see the famous or infamous, depending on, I guess, who you are, attorneys on television that are, typically spearheading those lawsuits. Those are civil rights cases as well, but those complaints are being pursued under different laws outside of the administrative enforcement that the Office for Civil Rights had.
Oh, okay. So they're interrelated in different areas, is what you're saying.
Absolutely, yes.
Okay.
There's a lot of interrelation, but there's, like, as my grandmother would always say, there's more than one way to skin a cat, right? And there's pros and cons to both approaches. Sometimes individuals might want to pursue civil litigation, which of course will typically result in the potential of like damages and monetary damages. But there's certain criteria that they had to meet. And so they may, I don't want to, get into like a super detailed legalese type explanation because those cases can be pretty complex, but there's certain criteria that those individuals might not meet, or they may not have the money to retain someone like that if they don't have a really well-known case. There just might be some things going on at the school that they just want rectified. And so that's where the Office for Civil Rights will come in and just make sure that the school was in compliance and providing the services that the parent was seeking. Because Office for Civil Rights, there were limited instances in which there were monetary damages, but typically it was more of corrective action. The Office for Civil Rights is an enforcement agency. So it's like, hey, school, we've identified that you're out of compliance here or potentially out of compliance here. We are going to come up with a plan for you to be in compliance and to provide the student with what he or she needs. And if you don't do that, then you might lose your federal funding. And so with that looming, we never, very, very rarely got any pushback because the schools really did want to do the right thing, to not only so that they would continue receiving funding, but also so that the students would have what they need in order to fully participate in the educational environment.
And you did say it, but I want to sort of reiterate a part of what you just said, which is that you do not need, or at least what I heard, is that you don't need to retain an attorney to have these types of rights protected for you. I could, if I had a child, contact the Office of Civil Rights, and that does not cost anything. Is that what you're saying?
That is absolutely correct. And I'm glad you brought that up. So sorry to like some of my colleagues, but I would always feel really bad when a complainant would contact me and say, well, I've got to get an attorney. Like I need to go and retain an attorney first.
Yeah.
And I understand, all right, if you're a layperson, this is your first time encountering this type of situation, you want to ensure that you're being an advocate for your child. You might think that retaining an attorney who's hired to be your zealous advocate puts you in a better position, but you are absolutely right. no one needs to retain an attorney in order to contact the Office for Civil Rights. They can contact them. The office is there to provide guidance, any questions that they have, if they have any legal questions, if they have any questions of administratively, etc. That's what the staff at the Office for Civil Rights are there for. So you're
And
absolutely.
should that, so should I contact whoever my closest office is, or does it all just go into like one area and they disseminate that to the proper channels?
So it's either or. There's a national number that someone could contact. It's an 800 number, and then they filled out the request to the appropriate office, or you can contact the office directly in your region. Like I said, there are 12 regional offices. So each office has roughly 4 or 5 states from a jurisdictional perspective. I will say that based on the jurisdiction that I was in, we were always one of the top 2 volume producing office. We always had a plethora of cases. I mean, Texas is a country by itself, just like California. So like counterparts in San Francisco, there's an office in San Francisco that handles California and the Texas, and then of course, Washington, D.C., because that's headquarters. Yeah. Those were typically like the top 3 offices as far as like the caseload, et cetera. So
I don't know if that's a good thing or a bad thing, but having all those cases, just glad that you guys are working through them for us. So thank you. Going back a little bit, how have you tied in DEI and equity initiatives with this civil rights compliance that you've been dealing with for 20 years, you said almost?
Yeah, so when I left the Department of Education, no one understood why. But as I stated at the outset of our conversation, that's kind of been the trajectory of my life. Like I really haven't followed the most well-beaten paths all the time. So with that said, one of the things that I had a number of events to happen in my life personally, and so it made me really reflect on what I wanted my impact, my legacy to be. And as I stated, you know, I wanted to work in civil rights even when I was in law school. And so I was working my dream job, I was doing civil rights work, but I began to think about how I could be more impactful in my role. And I think I did a lot of great work with the Office for Civil Rights, but as you mentioned, or as you alluded to, there's a lot of intersectionality. And that is something that I learned. Of course, you know, you think that compliance is, I look at it as compliance being the foundation, right? The Office for Civil Rights, the laws that are enforced there, it's like, that's the bare bones minimum. Because there's no way that you can, in good faith, say that you believe in DEI efforts or that you're trying to promote that, but you're out of compliance with just federal law, right? So if you're in compliance with civil rights laws, then you can build from there. And so it was easy. It was relatively easy to make that transition into doing more DEI work. Well, to transition into the DEI space in my consultancy roles. Like, as you mentioned, I did some work with the Windsor Group. I was a contract attorney. There I worked on a specific project, establishing the a new commission, a newly formed commission there. But I also worked with a lot of other consultants that did EEO work, and that's equal employment opportunity, and help them with like their DEI efforts and, you know, workplace policies, because a lot of it is very much so interrelated. Because as I noted, if you don't have a commitment to being in compliance with the civil rights laws, then it would be disingenuous to say that you care about DEI efforts, because the compliance is the bare bone minimum. And then after that, you build upon that to evolve into the other spaces of like DEIA compliance and initiative.
Right. And for everybody out there, we at EdPower do help to strict sanitary status. That's sort of how we got into this whole thing. And we help supply those reports that are needed to show the data that she's talking about. making sure that that is correct and that they're showing growth in some of the areas that they might be cited on. Side note. So
Well, and
let's talk
data
about,
is very important. I'm glad you made that plug, because it is very important. Even during my time at OCR, that's when the CRDC, which stands for Civil Rights Data Collection, really got up and running, and it was invaluable as far as like assisting with working on especially a lot of the race discrimination cases, like the school discipline complaints that I worked on. I don't know if I mentioned that sub area specifically, but I did a lot of work in with those types of cases as well. And as you know, they're very data heavy. And I think the great thing about EdPower, based on the work that I've done with you as well, is that your data and your platform is current, right? Like a lot of problems with the CRDC data, they were dealing with data from like 3-4 years ago, even to this day. And I mean, this is even pre-COVID. I know that COVID has stalled some of the collection for some of the various federal agencies, but even prior to COVID, there were issues with having the most current data and that people could use and see in real time. So data is definitely also the foundation of both compliance as well as the furtherance of DEIA efforts and initiatives.
absolutely. And that's how we met. So
Yes.
hallelujah.
Yes.
Okay, so let's jump into a little bit of gray area and talk about the most recent Supreme Court decision.
Yeah, right. So again, like I said, I don't want to get too detailed or too nuanced, because again, I want to keep this, I want to get into legalese. And that's one thing I will say too, like starting my career with the federal government, I think really helped me have an understanding of and eventually develop a mastery of being able to communicate with various populations and not use like a lot of the legal terms, but still get my point across. I literally have had people say, ma'am, I don't know what you're saying. Like, can you please say that in regular English? And so I learned from that. So I don't want to get into too much specificity. I'm sure, you can Google it. There's a lot of commentary, a lot of lawyers that have jumped in on this, and they still are, because it's only a month old. But I definitely see how there could be some, how it could affect different areas. Of course, the Supreme Court decision dealt with higher education. A lot of I know the work that we've worked on deals with cases in the K-12 space. However, the implications of the decision absolutely will impact other areas, including K through 12, as well as the employment space, because as I noted, a lot of the laws that govern all of those aforementioned spaces are very similar. Case in point, the Civil Rights Act of 1964, there's 11 titles. Title VI deals with race discrimination in schools. Title VII deals with race discrimination in employment. They're both titles from the same Civil Rights Act. So there are a few nuances, a few specific criteria that may not be applicable or may not be interchangeable, but for the most part, the law is the law. The intent, congressional intent is the same. They come from the same act. So there's definitely, I could definitely see how there will be some changes in some other spaces based on that particular decision. So, and I think we talked about perhaps maybe having a more detailed discussion down the road. I think that would be awesome to really get into more specificity there.
Yes, and for those of you that are watching this in the future, we are talking about the recent action decision that came down. I don't think we ever actually said that.
Yeah, the 200 and I think it's like 230 pages. So yeah, it's pretty prescriptive.
You spoke about the Brown versus Board of Education and the different titles. Would you mind sort of explaining, the work that we do in schools, I am usually surprised that no one knows what the green factors are and how they sort of got to why under unitary status today. Are you comfortable explaining the green factors?
Sure. And I will say that, so before I even get into that, that's another area, the green factors in desegregation cases, where it's anticipated this latest decision involving Harvard and UNC. So of course I was vested because that's one of my alma maters, will very likely have impacts there. So the green factors, again, I don't know exactly who all is on the call, but so let me back it up. I will say that I think there's a lot of frustration even maybe about seemingly always discussing issues of race. And again, I'm speaking from the education standpoint because that's what we're talking about here, but generally speaking, but particularly in education. But that is because a lot of the litigation is rooted in the Brown v. Board case that was back in 1954, that gave that birthed the Civil Rights Act of 1964. It birthed a lot of the desegregation cases, some of which are actually still active now. And so essentially, Brown versus Board said that separate cannot be equal when with respect to students being educated. And that stems from the 14th Amendment of the Constitution, which we often refer to as the Equal Protection Clause. So if you are familiar with the most recent affirmative action case, if you've read it, even read any articles that were written about it, you've likely seen that determination, the Supreme Court's determination was based on an analysis of the 14th Amendment, i.e. Equal Protection Clause. And so that's why, even though civil rights has evolved into a lot of other spaces, as I mentioned, like there are other marginalized populations that are affected, as I noted, sex discrimination, disability, those laws all came from the litigation that began based on the segregated school systems. And so I understand, especially like as a layperson, as someone who might not work in this area, it's like, oh my goodness, that was so many years ago. Like, why are we still talking about race? Well, even for the things that are, like I said, dealing with gender discrimination or dealing with disability discrimination, the litigation stems from cases that dealt with segregated schools. And then of course, like everything else in life that evolves, the laws evolved as well. And so with that said, after Brown versus Board, that determination came down, like I said, in 1954, a lot of litigation increased because some of the schools were not complying with that directive of integrating the schools appropriately. And so that gave rise to a number of cases that we often refer to as desegregation cases or deseg cases. And there were consent orders. So you might hear people say consent orders or consent decrees that were issued in those cases that gave each school district very, very prescriptive steps that they needed to take in order to come into compliance with being fully integrated. And being fully integrated is also referred to as unitary. So in order to maintain unitary status or attain and maintain unitary status, they had to follow certain steps. And the green factors, that case was from 1968, I believe. It lists 5 areas that, generally speaking, for all of the DSEC cases, the schools had to comply with in order to be declared unitary. And those 5 factors include, and my brain is horrible, so I'm going to make sure that I read those, right? That's one thing about, I will say that I'm not the lawyer who memorizes everything, but I'm the lawyer who knows where to get the information that you and I both need. But the areas include student assignment, faculty and staff assignment, facilities, transportation, and extracurricular activities.
Right. Yeah.
So those are the main areas. Of course, that those areas look a lot different back in the 50s and 60s versus now. However, a lot of the perennial issues that still exist are still rooted in those particular areas. So for instance, back then, student assignment might be, you can't have, you know, all of the Black students at one school and all of the white students at another school. It may not be that overt now, but there still may be some percentages that don't afford the appropriate opportunities for students of various races to be fully integrated to the extent that the court feels that they should be. So that's why I said that the affirmative action case, you know, I believe this, and I believe it's even being predicted that there could be some impact in those spaces, in the DSEC space, because one of the things that the court mentioned in the affirmative action case was, okay, well, you can't really say that you have this compelling interest to get rid of, you know, discrimination from the past, because societal discrimination isn't the same thing as like actual discrimination, which is what the court calls de jure discrimination. So it's like you actually have people separated. You know, an argument could be made that, hey, well, there's still, we still haven't achieved the level of integration that we need to in order to have a diverse society or to have an equitable society. However, the court read that very literally and said, hey, you can't just say just because there's a greater need for societal diversity that means that you can have this policy in place. And so that could very easily be applicable to the cases in the DSEC space as well, because I could see a number of groups coming forward and making the argument of, hey, we don't have segregated schools anymore. This is 2023. So even though, like I said, there might be some perennial issues that are going on, there may be some equitable or some equity issues that we need to address. There's nothing that's, you know, black and white that says that this school is not unitary. You need to release this from this order. So I definitely think that there will be an increase in litigation and appeals with respect to the current orders that are in place right now. That's my personal opinion. I'll take that as law, but that's what I think. It's on the horizon.
Being in at least 25 states since January, I can personally attest to the facility discrimination, and the differences within the facilities is definitely very apparent, especially in those little towns you're talking about with one to three schools. For me, I see that. And also, I think what I want to point out that was surprising to me doing this work is you started speaking about how all of these districts had to sign consent decrees saying we consent that we are going to change X. We still, to this day, have over 300 districts that are under a consent decree that are trying to attain unitary status, meaning all the way back then in the 60s, early, probably most of all the late 60s, early 70s, they were under these decrees that they still have not climbed out of. 300 plus districts. To me, we got to do some better work.
And I will say, even when I was with the Office for Civil Rights, that was an ongoing issue because of the time frame. Of course, we've evolved with respect to like our record keeping and how we document things. But with that evolution, a lot of times when you lose people, when people retire or unfortunately they pass away, you lose a lot of institutional knowledge. And so if you don't have a formal record keeping system in place, and it's not, the cases aren't those cases that like the government had to intervene with, there may not be a record. And so a lot of times I've frequently had conversations from now even to, almost 20 years ago when I started with OCR, I've had ongoing conversations with various individuals in districts, that superintendents, other high-level individuals who have no idea sometimes that their district is even operating under a consent decree. And then something happens, a new attorney is assigned, they're really eager, they're fresh out of law school. And so they give them a call and say, hey, what about this consent decree? And we're like, calling the Office for Civil Rights, or they're calling me as the consultant, or calling someone and calling you, and they're freaking out because they have no idea what they need to do in order to come into compliance. And again, just with the way that this latest decision was laid out by the majority of the court, it was a 6-3 decision, I could definitely see where there will be some challenges to the current consent orders that are effective right now.
Yeah,
based on that criteria.
I agree. I would love to hear your opinion. I also, and I don't think any of the districts we've been in, it has been known district-wide that they're under unitary status, or have a consent decree at all. And it's sort of kept under wraps. It's not really something that districts want their people or their staff to understand or know. But if that is you, and if you need help, reach out to us. We can help direct you, Tonya and myself, on the areas that you need to take a look at or even pay attention to, or how to get up from under that. We've been helping districts lay that roadmap in order to help do that. And Tanya's definitely been a part in at least 2 of the districts that we're in.
Right. And effectively navigating that too. And effectively navigating that too in this climate, because I definitely think that that's important. Even in the 20 years that I've been doing this work, the climate has evolved with respect to just, social media involvement and just various areas. Again, like you said, you've been working, said you were in like 25 states, I think, of the last few months. And I'm born and raised in the South, primarily worked in the South. So yeah, there are some challenges. And like I said, I can foresee there being some continued challenges that might look different now that we have this latest decision. But what I will say is that, again, and I'm remaining impartial here, just like I did at the federal government, just like I have in all of my roles, even when I was in my director role, even a consultant, I remain impartial. And I will say that I think that one of the good things about this latest determination, though, is that while the majority of the court did not indicate that race cannot be used, that affirmative action is illegal. I mean, they definitely scaled it back, but I think that it will cause the districts that are operating under these consent decrees, or even if they're not operating under the consent decrees, it will encourage them to better define what their goals are with respect to achieving diversity. And again, that's at the post-secondary level as well as the elementary and secondary level. And even though the affirmative action case, of course, is dealing with higher ed, a lot of the magnet schools now, they have admissions criteria. And so it can definitely spill over into the K-12 space also. There has been litigation at the K-12 level, but not as detailed as this latest opinion. So again, I think that I know that there are differing opinions surrounding the last decision, but I see both sides. And like I said, one of the good things that I think could come from this is with respect to not only those districts that are operating under desegregation orders, but just generally is if there are diversity initiatives, if there are initiatives to increase equity, or to improve with the 5 factors that we mentioned from Green, now is the time that those administrators and legal staff and data gurus, they will take that on and utilize this opportunity to get in front of it.
Right. So can you offer, and we have 5 minutes left, if you can believe it, we made it. Can you offer, what are some proactive steps or measures that a district or even higher ed could take to get ahead of all of this?
So I think that, again, as I mentioned, I don't want to sound like a broken record, but data is very important. Like, I think there's a song that says, men lie, women lie, numbers don't. And of course, there are men and women or humans that are interpreting the data. So there's still some room for interpretation. However, having current data that is easy to access and is reflective of what's actually occurring in the district will allow, or at a post-secondary level, will allow the administrators, or like I said, the legal team or your data people to get in front of it and prepare for, or as like I said, I always like to use sayings that like my grandparents or parents would say, run defense, right? Get ahead of the issue and anticipate what might be coming down the pipeline as far as preparation is concerned. Also, just being very proactive about understanding what resources are out there and drawing the dots there. As I said, I didn't really fully understand how, common sense told me that DEIA initiatives are, like I said, of course, related to compliance, civil rights compliance, because they're all in the same space. However, having an understanding of, the fact that there are, equity assistance centers, and having the understanding that you have EdPower, having the understanding that you have legal staff, consultants, PhDs, all of these people who have boots on the ground that can work together. So just identifying ways that you can pool your resources together to effectively address any areas of, like I said, compliance or even just any outstanding equity issues is a good step to take as well. And just, continue watching the news and ensuring that if there are some race neutral alternatives that are available that will still help achieve diversity or achieve the equitableness and inclusiveness that you're seeking as an environment at your campus, then pursue those as well. Have people proactively reviewing your policies, talking to staff, talking to your students, and having an understanding of what's going on from both the legal standpoint as well as what's going on in real time. I have a lot of things that I could probably recommend, Michelle, but I think we have 2 minutes. And to think I was worried about talking for a full hour, and here we are. So.
Yes, first of all, I want to say, every time you say you've been here 20 years, I'm like, you look like you're 20. So hallelujah for your genetics. And also to what we were just talking about, I really want to say that from a data perspective, and I would be remiss if I don't offer this advice from our perspective, is that you have to really dig into those non-traditional correlations, taking a look at what really is going on with your behavior, and is it affecting your performance? Is it affecting your staff? That's sort of something that we have specialized in going through this with the districts. We did not start that way, but learning and helping these districts come out of unitary status, we've started to understand that non-traditional correlations are very important. And the non-traditional correlations that you take a look at help you uncover the disparities that you need to take a look at. And so I feel like once you can uncover the disparity, then there's not really that tension, because there doesn't need to be, because the data just sort of tells you like it is. So if you need our help, we are here for you. EdPower, myedpower.com is our website. And Tonya, for those that are interested in your work or would like to have you consult with them, how do they contact you?
Yes, so I've actually taken a social media hiatus. So that's the one bad thing about having a career in civil rights, because you never, like, if you take a social media break, then you have to also take a break from like, your career, because it's everywhere, right? So that's a double-edged sword of it all. But I can be reached at T Gentry, that's TGENTRYESQ @gmail.com. And my phone number is, my business phone is 336-524-5548.
And that was 5548.
Okay. Shoot me an email, give me a call. And I hope that this is the start of, ongoing conversations. Like I said, we can maybe potentially delve more into not just the most recent affirmative action decision, but a number of Supreme Court decisions, and identify ways that we could look at what was addressed in those determinations and pair that with the data services that you provide, the data platform that you have. And like you said, just continue to provide support to schools that need us.
Absolutely. I'd love to have you back on for that panel that we spoke about earlier. But in the matter of time, I just want to thank you and everyone else for joining us today. And Tonya, good luck. We are so proud of you. Thank you for being that Buffalo Soldier, trailblazer in this field. There's not many of you. And so I really appreciate you coming on today and talking to everybody that is interested in having a career like yours. And for that, thank you so much for joining us today at the Table Talk for Education, and we will see you next month.
Bye. Thank you.